night on the CINA 102.3 app at CINAFM.com, on TuneIn, on smart speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me, fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. تحية طيبة، أهلا بكم مرة أخرى في راديو سينا 102.3 FM وحلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز. نذكر بأن مكاتب المحامية جومانا كيروز تستقبل كافة الاختصاصات المتعلقة بقضايا حوادث السيارات والإصابات الشخصية وقضايا الهجرة والتجنس والبانكربسي، كريمنال لو والفاميلي لو والسوشيال سيكوريتي، بالإضافة إلى إصابات العمل. 248-557-3645 هذا الرقم، بإمكانكم الاتصال للحصول على الاستشارات المجانية. وهذه الحلقات تبث مرة أخرى على الموقع الإلكتروني yourrights.com/radio أو على اليوتيوب. كل ما عليكم هو البحث عن قناة جومانا كيروز. أرقام الهواتف في الاستوديو 313-769-6666 519-256-123. تحياتنا لكم وأهلا وسهلا بك جومانا.
صباح الخير لك وللمستمعين وللضيف طبعا اليوم المحامي هاورد رادنر. Good afternoon, Attorney Howard Radner. How are you today?
Good afternoon. Good to see you, Joumana.
Good to see you too. It's another beautiful sunny day, and really spring is upon us. Very, very beautiful. We had a great weekend, and I hope for our listeners as well. Attorney Howard Radner, you've kind of created now a habit that you have to keep. You visit us once a month, and you educate our listeners about premises liability, slip and fall, trip and fall, injuries that arise, in malls, in gyms, in schools, arising because of, that's a sore subject for me, pet owners and unrestrained animals, city sidewalks. We're even going to talk about injuries, criminal activity around hotels and around ATM machines. So hopefully we're going to get to each and every one of those. They all fall within the category of what we call a premises liability, correct?
Sure.
You've been doing this for about 40 years. The number to call here today is 313-769-6666, and from Windsor, 519-256-1023. We visited about a month ago and we talked about several issues, 2 of which I want to go over very briefly. We talked about ICE, and you thought that perhaps I misunderstood or misstated what you were trying to say, which is that when you put salt over ice, ultimately the salt dissolves the ice. That's the goal. That's the intent. That's the purpose for which we throw salt over ice. The water ultimately evaporates, not the salt. And I may have misspoken, not intending. We know very well that salt does not evaporate. Salt will get washed out into sewers and down the road, therefore making the need to put salt again necessary. So again, when we talked about a month ago, we did not mean to say that salt gets dissolved. Salt dissolves ice and ultimately gets washed off. And that's why we need to replace it again every time the weather becomes inclement. Am I correct?
Sure, the salt doesn't evaporate, but rather it's washed away. It either goes into the ground or it goes into the sewage.
Or it goes here in Michigan into the Great Lakes.
Ultimately.
And you were telling me that the Great Lakes are becoming increasingly salty, and it's affecting the fish kingdom.
It is. It's killing some of the freshwater fish.
Mm-hmm. And it's an environmental problem.
It is.
So that problem or that solution that is supposed to be for our protection so that we can walk and drive outside safely is causing an environmental issue.
It's true.
Yes. And I think what you're implying is that there ought to be alternatives that are safe for us, but also safe for our Great Lakes, for our seas, and so forth.
Right.
Another thing that we talked about a month ago, we had several calls from listeners who rent from landlords, and the landlord passes on the duty to clean the common areas and to throw salt over ice on to the tenant. And I want to clarify what we talked about, and I want to state the law that applies to that. There is a law that says that a landlord and a tenant, so you said that under the law, under the statute, under the law, you cannot, as a landlord, shift your responsibilities to a tenant unless, and like every rule, almost every rule has an exception, and that rule does have an exception. If the lease is longer than 1 year, then the landlord and the tenant under MCL, Michigan Compiled Laws 554.139, they can modify, they can change what the statute say, and they can enter into a different agreement. Can you clarify a little bit further?
Sure. If there's no agreement, the landlord is obligated under the statute to maintain the common areas, make them fit for the purposes intended. For instance, a sidewalk, a driveway, a parking lot, a park, a field.
So that includes, among other things, cleaning, de-icing the area.
Right.
That's the general rule, because that's the rule under a statute. That's
true.
the law. It's black on white law. Except...
Also, there's a provision in that statute that the landlord has to maintain his premises in reasonable repair.
Okay.
So, for instance, he has to keep the handrail attached.
Is that something that can be passed on to the tenant if the lease is longer than 1 year?
That's the problem, that the statute does give the parties the right to modify those provisions.
Okay. So I'm going to quickly translate this into Arabic and clarify a little bit further what we talked about a month ago. من شهر رامي حكينا اجينا أكثر من اتصال المرة الماضية والمرة اللي قبلها من أشخاص هني مستأجرين عند landlords، والسؤال هو إنه اللاندلورد كتب لي بقلب العقد إنه أنا كالتننت، أنا المستأجر، أنا المسؤول عن تنظيف الأرض، أنا المسؤول إنه حط ملح فوق الآيسي أرياز، أنا المسؤول على التصليحات، مكتوبين بقلب العقد. القانون بيقول، ونحن اليوم عم نوضح شوي، القانون بيقول إنه القانون كقانون بيقول إنه ما بيقدر في واجبات لصاحب الملك، ما بيقدر حتى لو كتب عقد يعطيهم أو to pass them down أو يعملهم مسؤولية المستأجر، حتى لو كان مقابلة بأجار مكلف أقل منهم، إنه الcommon areas، إنه نحط snow على الآيس إلى آخره. وإنما اليوم عم نوضح إنه هيدا هو القانون، وهي القاعدة العامة، إنه هيدول المسؤوليات دائما مطلوبة من صاحب الملك. ما بيقدر المستأجر حتى لو رضي، حتى لو volunteered، حتى لو اللاندلورد قال له بأجرك أقل، ما بيقدر يطلب اللاندلورد حتى لو كان في عقد بين الطرفين إنه هيدول المسؤوليات تبع اللاندلورد يصيروا مسؤوليات المستأجر. exception في exception إذا كان العقد مدته أكتر من سنة، يعني ليلي بيدخل العقد أجار أكتر من سنة. أغلبية عقود الأجار رامي هن سنة أو هن month to month، بده يكون أكتر من سنة. إذا كان أكتر من سنة القانون بيسمح بexception بشغلة استثنائية وبيقدر ساعتها صاحب الملك أنه يطلب بالعقد من المستأجر أنه هو يقوم بهيدي الأشياء. وأغلبية الأوقات رامي بيشيلن من مسؤوليته اللاندلورد وبيعطيه بيشرجه أقل شوي استئجار. نعم. هيدي نقطة توضيح حبينا نقولها. Very good clarifications. We want to remind the listeners that the numbers to call here are 313 769 6666 and 519 256 1023. Again, 313-769-6666, 519-256-1023. We welcome your calls to Attorney Howard Radner, who has about 40 years of experience. 44 years of experience dealing in matters of personal injury, and you have created a very successful track record in premises liability, slip and fall, trip and fall. You worked for the office for a short while. Prior to that and after that, you have continued representing all of our clients in matters that have to do with slip and fall, trip and fall, premises liability, and even other matters. But today we're talking about premises liability. We have a call? Okay. We will take our first call.
Hi, how are you?
Very good. Who are we speaking with?
Jenna.
Hello, Jenna.
Actually, Attorney Howard represented my brother 2 years ago. He got into really, really bad slip and fall, and even required surgery. And we were so lost on what to do. Number one, we're worried about our brother. Is he going to make it out of this? He really hurt himself really bad, and Attorney Howard really helped us through it and held our hand through all of it. And I want to thank him. And also,
was that through our office, or?
And yeah.
Okay.
And of course, Joumana, thank you so much. You helped us also. I listen to you all the time on the radio, and I learned so much. And you know, it helps us prepare for what if we ever get into car accidents and situations. And you're educating people that have no idea what's going on. You know, and getting to know our rights.
Thank you. You're very kind. Thank you so much, Jenna. And thank you for calling Attorney Howard. He's shaking his head. You're not going to know who that is because she probably wants to keep her brother's identity. Suffice it to say that you did a very good job for her brother in a slip and fall.
And I hope your brother's doing well, is he?
Yes, he's doing much better now.
Jenna, did you mention, and I apologize, you may or may not, did you say your brother had surgery or no?
Yes,
I did. He did.
Yeah.
Okay.
It was a big surgery, so thank you, Attorney Howard, so much for helping us through this tough time in our life. My family really appreciates it. And
thank you, Jenna. You're very kind to call and have good things to say to him. Thank you very much.
Thank you, Jenna, very much. I wish you and your brother the best.
Thank you. And we will take another call. Hello.
Yeah, hi. Hi to everybody there.
Everybody is having a very good day and a very blessed day. And who are we speaking with?
Ray Fayyad.
Hello, Mr. Fayyad.
Hi. My question is about this, about the house. It should be house or business or both.
It can be, you can have, are you talking about an injury in a house or an injury in a business?
No. I'm بحكي أنا على عقد الأجار.
Okay, contract between landlord and tenant, yes.
Yeah, the landlord and tenant.
Yes.
Either business and home or just a home.
Okay, I think that Mr. Fayyad just heard us talking about how Michigan compiled law that we mentioned does say that when there is a contract between a landlord and a tenant, if it is under 1 year, the landlord cannot make the tenant responsible for the common areas. Mr. Fayyad wants clarification. Does that apply to residential or commercial or both, is his question.
This refers to residential.
Residential. So, Mr. Fayyad, we're talking about a private landlord and a private tenant, not in a commercial business.
Thank you very much, and you guys have a wonderful day.
Thank you, Mr. Fayyad. Thank you very much for your wonderful question. And we take another call. Hello?
Hello?
Who are we speaking with?
Yeah, my name is Naeem.
Hello, it is Naeem.
How you doing?
Very good, sir. How are you?
I'm all right, thank you. I appreciate it. Ms. Joumana, I want to ask a question. I'm a driver, and I drive all over.
Yes.
And one of the states I was like picking up a load, somehow I heard my left bottom feet. I heard it, and I went to a foot doctor. They told me I have to do surgery. It's going to take about, I have to stay home for 2.5 months. I don't want to do the surgery really, but I've taken pills, all that, but it keep hurting me. But just do I need to hire an attorney for that?
So I think this is outside the scope of today's discussion. However, let me ask you so that I can direct you. Are you saying, or are you telling us that the bottom of your feet, because you are a driver, you injured the bottom of your feet within the scope of your job?
I injured it when I was picking up a load at one of the warehouses.
Okay.
I injured it at the warehouse.
Okay. So Mr. Naeem, what you're talking about is a work-related injury. It relates to the scope of your employment, what you're asked to do as a driver, loading and unloading, attendant to being a driver. This is called this is a workman's compensation injury, and I would ask you to ask for attorney Michael Roth, who will be with us next Tuesday. He is the one who specializes in workman's compensation in our office and Social Security. Workman's compensation and Social Security. So you feel free to call our office. But let me tell you, Mr. Naeem, when you ask the question, do you need a lawyer? The question is not whether the law requires you to have a lawyer. The question is whether or not you are capable of doing something and doing it as competently as a lawyer could in your particular situation. And that changes depending on, your level of sophistication, the difficulty and the complexity of the matter that you're dealing with. You may or may not need a lawyer. My recommendation to everyone listening, when they not sure if they need a lawyer or not, that's okay, as long as one is honest. It's okay to seek a free consultation and tell the lawyer, don't know if I'm going to hire you, don't know if I'm going to hire a lawyer. I'd like to know, I'd like to have a consultation and find out, how complex, how easy what I'm looking at is. And then you will come out of that consultation more informed about whether or not you have the time, you have what it takes to represent yourself. And I will tell you, Estes Naeem, it all depends on the medical records with you. If the doctor for the workman's compensation lawyer, related clearly that what's happening with your feet is because of an injury on the job, they ought to be paying your wages without any issues, without, the intervention of any lawyer. But I will leave it at that because we're talking today about slip and fall and matters like that. Feel free to call our office if you so chose, of course.
I appreciate it, and thank you for your advice.
Not a problem.
Thank you.
Not a problem. Attorney Howard Radner, occasionally will get a call. Most listeners, they will call about what we're talking about, but sometimes they don't know what specifically we're talking about. We're talking about premises liability today, and we have half an hour. 313-769-6666, 519-256-1023. If you fell, in a gym, in a school, in a hotel, on a city sidewalk, visiting a neighbor, maybe an injury because of unfenced swimming pool. You may have been, God forbid, the victim of a crime when you are around a bank and you're drawing for the ATM. It's like a new cause of action that I'm starting to see. And I know it depends. The victim of a crime. Does that mean, let's say, a hotel, and let's say the hotel, doesn't have adequate surveillance or lacks surveillance cameras or secured, locations, and then somebody becomes the victim of a crime. That is an injury, that could be, could give rise to a premises liability issue. Have you seen, I was doing my research in preparation for today's show, and I saw that a number of people across the United States, not in Michigan, I have not come across a case in Michigan. That does not mean it does not exist, but that means it hasn't made it to the Court of Appeal or the Michigan Supreme Court. people who are filing lawsuits because they were attacked while they were drawing money from from an ATM, inadequate security, inadequate lighting, and so forth. Have you come across this? And if somebody called you with that question, how would you deal with that?
Well, generally in Michigan, there's no duty to provide security to one's customers. The Supreme Court stated that decades ago.
The Supreme Court said
in our state that there is no duty on the part of the proprietor, the owner of the property, to provide security.
Okay, and what is security read to mean?
Say security guards.
Okay.
But once the proprietor does have security personnel in place, then they must act reasonably.
Okay.
So, for instance, if you're a store owner who hires a security guard, and because he gets intoxicated during his lunch break and he can't perform properly, and somebody gets attacked and he's not there to stop the attack, then the store could be liable because he has security and the security is not acting reasonably.
So once you establish precedent in providing security for your customers, let's say you are a Meijer, you are a Kroger, and you want to make sure that people outside, they can shop late in the evening, but provide for them the most safe environment in that you put security guards outside to make sure that the area is crime free, etc., because you want to encourage people to come and shop without worrying about their security. Once you put that out there, if something happens because the security guard is not paying attention or acted negligently and is not watching the area, then the business can be liable and you have grounds for a premises liability.
Right. Another example would be, say you're a customer in a bar or a restaurant. There are bouncers there to prevent fighting, and a fight breaks out and the bouncers don't do anything.
Okay.
Or the bouncers intervene and they hurt you. So then you'd have a premises liability claim against the proprietor.
And that is a negligence claim. That's different than assault, which requires an intent.
That's right. It would be a negligence claim.
What about in gyms? A lot of people go to gyms,
well,
and sometimes they get injured. This is a little bit of a tricky situation.
The gyms that I'm familiar with all have releases of liability. When you sign up for the membership, you are in the fine print. You're waiving your right to sue for negligence.
Okay, but are you waiving your right to sue for anything under the sun?
No,
I think not.
Not gross negligence. The law, as it's been articulated by our courts, states that in Michigan you can never waive gross negligence, but you can waive ordinary negligence. So people that belong to gyms are usually going to be barred from suing for any type of negligent injury that occurs on the premises.
Okay. We are talking today with attorney Howard Radner, who has 44 years of experience representing injured parties in slip and fall, trip and fall, and premises liability generally. Premises liability is more than slip and fall and more than trip and fall. Let's say an injury in a hotel because of, inadequate surveillance or, like we said, security guards that were there but are not doing their job. That is not a slip and fall. That is not a trip and fall, but that's an injury that happened on the hotel premises, and that's what we call premises liability. So premises liability is an umbrella under which we have slip and fall, we have trip and fall, but we have other injuries. It could be, for example, an unfenced swimming pool when your neighbors. I know that most cities, if not all cities, have zoning laws regarding swimming pools, correct?
I'm not sure.
I think that is fair to say, because it's a common it's an attractive nuisance, I think they call it, because there is something attractive about the pool water for children, so it does attract them. So there are I will bet you every city has zoning laws, municipal laws about that. I know my city does, and I know it's not the only one. But an injury in an unfenced swimming pool can also give rise to a premises liability. Let's talk about a very common scenario. Someone goes to visit their neighbor. I am visiting my neighbor, and then an injury happens. First off, just because an injury happens does not mean somebody was negligent, right or right?
Certainly.
Okay. So this is the case in medical malpractice. Just because there is a bad outcome because of a surgery does not mean the surgeon did wrong. In a car accident, just because, God forbid, there was a collision, with another car, does not mean that the other car was negligent. And same here. Just because you go to a place to shop, whether you are an invitee, or whether you are a licensee, or whether you are a trespasser, visiting a home, visiting a gym, visiting a church, visiting a mosque, a hotel, walking on a city sidewalk, just because something bad happens does not mean that someone was negligent, correct?
Correct.
Okay. Having said that, what do we need to prove so that there is negligence?
Sure. Well, you'd have to prove that there was a defect or a defective condition or a dangerous condition on the property that the owner knew or should have known about.
So that's the key. So again, as far as those people, and this is a very common scenario, most people visit their neighbors. Just because something bad happens does not mean that your neighbor that you're visiting was negligent. However, in order to hold the neighbor liable, you have to be able to show that your neighbor knew there was something wrong with what caused you an injury, or should have known, because any reasonable homeowner would have known. So she or he should have known. And if you can prove those two, that you go to your neighbor and what caused you the injury is something that your neighbor should have paid attention to, and put a taken measures or told you or forewarned you, whether it's a sign or whether telling you in person, but did not do it. Correct? Okay. What about dogs, pet owners? That's another increasingly common scenario.
Well, there is a statute in Michigan that creates strict liability on the part of the owner of a dog when the dog would bite somebody in an unprovoked manner. The law, the statute in the state of Michigan states that the owner is responsible.
What if the dog does not bite, but the dog's actions cause somebody to trip, fall, and injure herself or himself?
Right. Well, there would be
there could be negligence now.
There could be negligence on the part of the homeowner if the homeowner knew that the dog had certain propensities, let's say to to do things that are dangerous.
Yeah.
And didn't warn the neighbor about it.
And sometimes you can warn the neighbor with as little as a sign says, "Beware of dogs." You have the UPS, you have the Amazon people coming to your home. They're coming within the regular course of business. There is no way for you. You cannot stop them. They are performing their jobs. And we call them, I believe, licensees. We don't want to complicate it for listeners. And for those people too, for that group of people too, you have a duty to keep as a homeowner your premises, particularly outside in this case, reasonably safe. That means if you have a dog and the dog has any propensities, the dog should not be outside.
That's
because if the dog, and if I understand you correctly, if the dog bites someone, then you don't even need to prove negligence. You have a law that allows you to seek compensation from the owner under their homeowner's insurance. But even if the dog does not bite, but the dog scares and causes someone to trip, fall, any injury not having to do with biting, then if you can prove that the owner knew that this dog, has a propensity and should have taken measures in keeping the dog in and or other measures, keeping the dog in the backyard and so forth, then the owner was negligent.
Sure. We did have a case once where the postal carrier was knocked over by a dog and sustained a back injury. And we sued the homeowner, and the homeowner was found responsible for that, even though the postal carrier was not bitten.
Yes.
But she was attacked and knocked down.
Right. And you were able to sue the owner because the owner knew or should have known that dog is overly zealous or had propensities that can cause an injury.
Also, there are many cities that have an ordinance that require the dog owner to keep the dog fenced or leashed, so that you can't walk around. You can't allow your dog to walk around it freely outside.
Would an invisible fence be called a fence?
I think it would be.
Okay. Although those invisible fences, they are prone to error. They don't always work, because the way they work is, as the dog nears the invisible fence, the invisible fence emits a radiating, painful shot to the collar of the dog. Sometimes the dogs, their immunity increases, and they can get beyond the initial pain and still jump through the invisible fence. So I think what we need to, talk about here is, as it pertains to dogs, that as more and more people are having dogs, as a landowner, as a homeowner, your duty is exactly like your duty would be if you have broken, stairs outside, and someone who's either visiting you at your request because she or he is a invitee, or whether it's somebody who is taking care of business within the scope of her or his business, like a UPS, postal worker, Amazon, FedEx, then, or even a trespasser sometimes, but we're not going to make it very complicated. You do have duties with the dog, and maybe the safest thing is to keep the dog outside or fenced in the backyard. But like you said, that there is, go ahead.
Yeah, I was just going to say, there are sometimes occasions where a delivery person or a mail carrier will approach the home. The homeowner will open the front door, and the dog will jump out of the house and bite the delivery person or the mail carrier.
Yes, and that's the same. It's the same. So you may falsely think that if your dog is inside by your side, if you don't have control over that dog when you open the door, then you have lulled yourself into falsely thinking that you've eliminated the risk. You may have reduced the risk but not eliminated it.
So the best thing would be for a dog owner to keep a dog in a different room with the door closed when somebody's coming to the front porch.
Sometimes you don't know that somebody is coming, but the dog will often bark, and that would be your tip, to take the dog and put it away.
And then open the door, the front door.
And then open the door. But again, I think that to all those who are listening, I know increasingly Middle Eastern people particularly are getting dogs, and this is becoming a rampant situation, and we want the dog to be also safe, because if the dog bites, this is heartbreaking, but the dog may be put down by a court, and we don't want that either. We want to remind the listeners that we are talking with attorney Howard Radner, 313-769-6666, and from Windsor, 519-256-1023. Some of the do's and don'ts, I get asked that a lot when it pertains to a car accident, do's and don'ts. As soon as you have sustained an injury, which you believe to give you grounds for a premises liability lawsuit, what are some of your do's and don'ts?
Well, one of the things that we always ask for were any photographs taken of the alleged defect or defective condition in the property.
So I guess what you're saying is, one of the do's, when reasonably safe to do so, take photos contemporaneously with your injury at the moment. When safe to do so.
Right.
Okay.
And
what
if you
else?
can't do it at the time, have somebody take them shortly afterwards.
Okay.
Now, we had a case yesterday in court where the other side was using a photograph of the sidewalk where our client fell.
Well, it was fell on ice.
Fell on ice, an icy sidewalk with snow-covered ice. when the photograph was taken, already the snow and ice was gone from the sidewalk.
So that was not helpful. And congratulations, you won that motion for summary disposition in Macomb County. Before we continue into more do's and don'ts, and we have a couple that are very interesting, let's take a call. Hello.
مرحبا.
يا أهلا وسهلا.
كيفك ست جومان؟
يا أهلا وسهلا، مع مين عم نحكي؟
خالد.
يا أهلا أستاذ خالد. Go ahead, please.
I have a question for the
Attorney
lawyer.
Howard Radner. Yes.
Okay, I'm a mail courier. And
You are a what? Mail courier, yes.
Yes, and a few of my friends got bit by a dog. And the question is, how about if the dog owners don't have insurance?
Yeah.
What's the situation in this?
Yeah. So if dog owners do not carry homeowners insurance, what is the remedy? Well,
unfortunately,
if they
not
are not
much.
collectible. So Estes Khalid, this is no different than when you get hit by a car and the other driver has no insurance and you don't have protection. It's no different than the case when we won a $250,000, I believe, default judgment because the landlord and that landlord-tenant injury had no insurance on his building.
Right.
We got a judgment, all right, but we got no money
Not
on
collectible.
it. Not collectible because the landlord can file bankruptcy,
Right.
correct? The same here, Estes Khalid. If the homeowner does not carry homeowner's insurance, and correct me, Attorney Howard Radner, in the law of Michigan, there is no duty as of today to buy homeowner's insurance on your home.
That's very true.
Except if you have a mortgage on a home, they need continuous proof of homeowner's insurance.
Yeah, because the bank isn't going to write a mortgage if there's no.
That's in the beginning
insurance.
of the mortgage. But I don't know how often a bank will go back to check that you have maintained your yearly homeowner's insurance. But there is no duty. And if the homeowner herself or himself have no money, Estes Khalid, you can sue them. You can ask for $1 million. And the judge will give you $1 million and you will not be able to collect. And even, they will take that default judgment, they will file bankruptcy, and it will be discharged in bankruptcy. That's why we always like insurance, because we know that the insurance is not going to file bankruptcy, and even then. So when we're suing a person, whether it's in a car accident or whether bitten by a dog, if the homeowner does not have insurance, then...
So in this case, if the person got hurt and he can't work no more, what's going to happen in this situation?
Did the person get hurt by a dog?
Yes, bitten by a dog.
And because of the dog bite, he can't work any longer?
Yes.
And this homeowner was uninsured?
Yes.
Out of luck. I'm very sorry to say the injuries are very big. Yeah. Is there anything a mail courier or an invitee or a licensee, because a mail courier would be what we call a licensee, is there any insurance that they can purchase to protect themselves against the risk that sometimes homeowners do not carry insurance?
I'm not familiar, honestly.
Neither do I. However, what mail?
Anybody
you are a mail courier for what? For the United States Postal Service?
Yes.
Okay.
Anybody can buy. Just to answer your question, Joumana. Anybody can buy a disability policy.
Oh yeah, we do have that. Yeah. I'm just asking the dog owner's side. I mean, in my job, yes, they offer to buy disability insurance.
Through whom? Through your employer?
Yes.
And this worker friend of yours would have workers' compensation through the post office that he would be entitled to receive if he was disabled.
He will have workers' compensation. His or her medical bills will be paid. Her or his wages up to about 75% will be paid, but no damages for pain and suffering.
Correct.
No damages for pain and suffering. And if this mail courier indeed cannot work because of this injury that, was arisen because of a dog bite, then the settlement with the workman's compensation insurance will be for the rest of his work life. So it will be a much larger settlement, but it will not be a settlement for pain and suffering, correct?
Correct.
Okay.
There's also a possibility of Social Security disability.
That's right. And that's a separate thing as well. So in other words, Estes Khalid, and that's a wonderful question. If the homeowner, and the law in Michigan does not require a homeowner to buy homeowner's insurance, if the homeowner does not buy insurance, unless the person who came to the home through, for example, your mayor was there within the scope of his employment, then will get treatment, will get wages. If indeed cannot work for the rest of his life, his settlement with the workman's compensation insurance company will be much larger because it will take into account all the years he would have been able to work but cannot work because of that injury. But there is no recovery for pain and suffering. Now, Estes Khalid, if you take that same scenario in a car accident, you can buy insurance. That's what we call uninsured motorist coverage that we advise people all the time to buy, very cheap to buy. You can protect yourself against drivers out there who don't buy insurance on their car. Unfortunately, in the context of a homeowner's insurance, there is no such insurance. And I also want to add, and thank you for your call, Estes Khalid, I also want to add that disability insurance, depending on who it is, can be extremely expensive. For example, for me, it's prohibitively expensive to purchase disability insurance. Perhaps for other people, depending on what they do, it's not that expensive. But again, you can look into buying disability, which is for any disability, you know, the insurance will be there to pay a percentage of your wages. But that again is for just wages. Can also, not sure, can include medical, but is not going to be for pain and suffering. There is no pain and suffering. We want to go back to the do's and don'ts. One of the things you did say is, and you were talking about a motion that you were able to successfully beat, that the insurance company for, what was it? Who were you suing without giving names?
Condominium complex.
Okay, you were suing the condominium complex, and the insurance company for the condominium complex filed a motion to get your case kicked out because of ICE. And they presented a photo, but the photo was not what's the right word? Contemporaneous. The photo was after the ice melted.
Right.
And the Judge Servito, found in your favor and dismissed their motion, and the case continues.
That's right.
They will still have that issue later, but for now, you know, it makes your case much stronger.
The reason he denied their motion is because the snow and ice on the sidewalk was effectively unavoidable.
There was no other way to go around it.
There's no other way to get to her car.
Very good. So your first tip is, in a premises liability, whether it's a slip and fall, trip and fall, or any injury at a business, at a home, at a gym, at a school, at a hotel, at a city sidewalk, your first tip is take photos. And if you can take them when reasonably safe, so to do them at the time contemporaneously because the conditions have not changed, then you eliminate that argument on the part of the other side that the conditions have changed. So take them then and there if possible, if not as soon as possible thereafter. Any other do's and don'ts?
I would say a big don't is to be very careful when the owner of the property or the manager of the property presents you with a
settlement,
a incident report, and asks you to write down what happened.
Oh,
yeah. Better not to fill that out.
Oh, so don't fill out an incident report.
Better
and
not.
You can simply do that?
Sure. You can
and
refuse.
Why do you recommend that?
Because you may say things in there that you don't mean, or they will be misinterpreted to your detriment.
So it is better is there a requirement under the law for coverage or anything like that?
No.
Is there any requirement that you do fill out an incident report? No. Even if that policy has some money for medical treatment, that could be different and you will need to submit an application.
I'm not sure if there's a requirement to get medical treatment to fill out an incident report.
But by then you should consult with an attorney.
I would recommend not doing it without consulting your lawyer.
Okay, so this is a new piece of advice that I heard today. Your recommendation is not to fill out an incident report where the incident has happened.
Right.
Okay, and you can simply refuse And you
Sure.
can say to the person, please talk to my attorney.
Sure.
Okay.
They have an attorney and you should too.
Okay. They have an attorney and you should too. I like that. They have an attorney and you should too. I'm going to borrow that and put it in an ad. Any other pieces of
I would
advice?
say if there are people that saw you fall, or saw you
Witnesses.
get injured, to get their
Witnesses.
names, addresses, and phone numbers.
Correct. Get the names and the addresses of any witnesses. What about look for security cameras?
That's always nice to have.
It's always nice to have security cameras are on the increase for crime prevention, if nothing less. There was a big headline in Detroit about a week ago that they're putting cameras pretty much everywhere for the sole purpose of reducing crime. And so look for security cameras in the area around you. Any other do's or don'ts?
Yeah, and the reason why the security camera is important is because if they're taking surveillance of the incident that you're going to sue over, then your attorney is going to want to contact the management and ask them to
Preserve.
not destroy that evidence. That would be called spoliation. So we don't want that evidence destroyed. And if they're on notice, if
They
there's
will
a
not.
potential claim, then they're not allowed to destroy the evidence.
Okay. However, if you do not, as the attorney, do not put them on notice, then they may or may not need to preserve that evidence
That's right.
depending on what their insurance company requires them to do. Some insurance companies will require them to keep it for 14 days, some longer. So if there are security cameras that have caught the incident while it's happening, it's very important that you or an attorney on your behalf send a letter ASAP putting them on notice not to destroy the footage. Otherwise, if they do that, now they've spoliated the evidence and the judge will find in your favor, as if there was something in there that they've hidden that is really in your favor.
Another don't would be that if you're contacted by, let's say, the insurance company for the landlord, he wants to take a recorded statement from you over the phone. He'll be very brief. He'll just ask you a few questions, and he asks you your permission if he can record your statement, then just kindly decline.
Very good. Any other do's or don'ts?
And stay off of social media.
Thank you. Do not discuss this on social media. Do not discuss your car accident on social media. Do not discuss your work-related injury on social media. Do not discuss your divorce on social media. Do not discuss any criminal matters on social media. And do not discuss your slip and fall, trip and fall, or any other injury that's called a premises liability on social media. And what can you tell us about that?
Well, the insurance company will have a way of monitoring your postings, and you'd be surprised that you'll be sitting in a courtroom 3 years later, and they'll be putting your postings that were put on the social media on a great big screen for the jury to view.
And, you know, they say that a picture is worth 1,000 words. And sometimes a picture that you believe is innocent may be read to mean that you are not as injured as you claim you are, or you're not injured, and so forth. So it's, and words the same. Words can also be interpreted. Once you are in front of a jury, it's going to depend on these 7 jurors, what they're going to think. And why do that? Why put yourself in a situation where you are now, your actions, your pictures, your words are subject to interpretation? We have that same issue with car accidents as well. And some people think that if their social media is private, that the insurance company cannot access it. And that is not true. Some people also think that if they put things on social media and they delete them, that likewise, the insurance company will not see them because they've been deleted. Not true, because once the social media is going to be subpoenaed, they're going to go to the mother company and it's going to provide them not with the cleaned up version, not with the public version. It's going to give them the private version if it's private. It's going to give them everything before it was deleted. And increasingly those judges are allowing those motions.
And then along the same lines would be text messaging, after you've been in an accident, or emailing about the incident. Those are all going to be available to the insurance company to go over with a fine-tooth comb.
Very good. Attorney Howard Radner, I want to thank you very, very much. There was a lot we didn't have a chance to go over. Maybe we can talk very, very quickly, since we have 3 minutes, about one thing before we wrap it up. Payment of medical expenses. People assume that if you're injured at a place, at a business, or at somebody's home, that place, that business, that Kroger, that Meijer, that hotel, that theater, that gym, that school is legally obligated to pay your medical expenses arising out of the injury. Right or wrong?
That's wrong.
Wrong.
There are some companies that have in their insurance policy a MedPay provision, which allows the person to collect medical bills reimbursement up to a certain number.
Okay, and the number is very small.
Very small.
I mean, it's probably 1,000 or 2,500 or 5,000 if that.
If the proprietor of the property offers to pay you medical bills, be very careful of what you're signing in exchange for the check.
Because you may be
a full release of liability.
Without you knowing it. That in exchange for paying your medical bills, you promise not to sue.
That's right, for your pain and suffering. And you might very well have a valid claim for pain and suffering if the proprietor were negligent. But if you sign a release giving up that right, then you can't sue.
And very quickly, Attorney Howard Radner, does the payment of medical bills for those insurance policies that have a medical bill pay or MedPay, does it require that you prove that the landlord or where you fell there was negligence?
No, not at all.
Just having the injury there, whether somebody's at fault, not at fault, if that policy has it, you will be able to enjoy it. Just make sure that you're not releasing your rights otherwise, but you're just enjoying coverage of some of your medical bills. And it's very, very small.
The best thing is to show the release to a lawyer before you sign it.
That is if it is a release. Yeah. Okay. Attorney Howard Radner, I want to thank you very much for coming. I know you're very busy and you're giving us of your time monthly. This tape was loaded with information. And Rami, with your permission, can we run this tape instead of our usual immigration tape this coming Sunday at 7 p.m.? People can also find this tape on our website within a couple of days, YourRights/radio, and they can also go to our YouTube channel, Joumana_Kayrouz. Joumana Kayrouz YouTube channel. You can subscribe, and every time we download a tape, you will find it there, and you can listen to it if the subject interests you. Thank you, Rami. Thank you to all the listeners. Thank you to all the callers who added a lot of information today to our show. Mr. Fayyad, Estez Naeem, Estez Khalid, you all added a lot. And our first caller as well, who called to thank Attorney Howard Radner for the wonderful work he did for her brother. Thank you very much, and God willing, to Thursday, 12 p.m.
Inshallah. Shukran.